All right, we'll give it a couple more seconds here and we'll get started on it. I just wanted to go ahead and introduce myself and just give a quick introduction and thank you all for being here as we wait to get into more of the substance of this. But thank you, our firm, Holmquist and Gardner. We like to put these webinars on. We think it is a value add to not only our colleagues, but our clients and everybody out there in the industry that has these questions. And we try to keep these webinars to practical components of issues that we're seeing a high level of. And so for today's webinar, we are looking at the navigating the eviction landscape and kind of some updates to where we are. We're going to be focusing on both the residential and commercial side of things in the webinar today. And so it's a background. If you guys have not participated in one of these with my colleague here, Mr. Phil Neal, and myself, we are very open to questions throughout this process. So if you are familiar with this Zoom format and everything, there is a area where you can type in and chat, and it will throw up questions as this is going through, and we value that input during the process. It makes us a more collaborative and beneficial for everybody when we're saying, hey, you know, I have a question on this particular point that you addressed, or even if it's just a question of, hey, this is happening, you know, what are some high-level thoughts on it? So take your time, and if you do have a question, don't be shy in throwing it out there for us. We'd be happy to address it as the time permits. But then on that note, I think we will get going on the webinar here. And so again, for those of you that don't know me, my name is Robert Maxwell. I'm a partner here at Holmquist and Gardner. Our firm is located in Seattle. We do a ton of things, but our main focus here is real property, business, and estate planning. So we've got a whole team of people ready to serve the community and help. If you've interacted with any of us, hopefully you've met a few of us and can see how much value add there is to the greater community, and we love being a part of that. I'll go ahead and let my colleague here introduce himself as well.
Thank you, Rob. My name is Phil Neal. I've been with Holmquist for over 2.5 years now. Before starting with Holmquist and Gardner, I was working primarily in high volume eviction work. I would sometimes have as many as 80, maybe and up to 100 cases at a time. I don't do high volume work anymore, but still plenty of evictions on my plate, as it has been a hot topic as of late. I've loved my time here. I've been able to expand my knowledge in other areas of landlord tenant law and real estate in general, and so far it's been great. And I think it's always interesting to interacting with my clients about the new developments in landlord tenant law and how we plan to address these developments as well in terms of our eviction strategy.
Right. And the biggest part of this, we did this about the same time last year, and it's just, we have been in, if you guys had any practice in this area, any experience within this realm, you know, pre-COVID, there's kind of this, these trains or these errors of where this all went. And pre-COVID was a completely different ball game. With all the different laws that came into place, all the different protections, all the different hoops and everything to go through now, the eviction side of things, and the unlawful detainer is the legal term for it. But the unlawful detainer aspect of the courts is kind of, it's been in a constant state of flux. So there's always been updates. There's new case law that continues to come out because there's always new laws that are coming into play. The arena is ever shifting, and that's putting it lightly. So it's kind of hard to determine or see from the outset where a certain aspect is going to go. But we've seen enough of these, so we've got a ton of experience firsthand within the courts and within the different counties to answer questions on this front. But the biggest thing we wanted to do is just open it up, and if you did have specific questions, let us know. And I think, Jobel, if you can go to the next slide, there is a question section here. So go ahead and put that in if you need it. And like I said, we're talking on the eviction landscape. And so the one first thing that I wanted to run through, and this is for any of those commercial owners, commercial property managers out there. There's a big update in the city of Seattle, and this is specific to the city of Seattle. There's been some pretty critical changes that have come through as of January. I think it came into place January 27th of this year. But the big part of it through, you'll see there, Ordinance 126982, and that's in Seattle. And we have a link that Jobel can share in the chat for kind of the summary of these new requirements for a commercial lease. But there are some big practical changes for commercial owners in Seattle. And some of the big things that it's addressing is the reality of what can be done for a security deposit on a commercial lease and what can be done for personal guarantees on a commercial lease. Now, there's a lot of leases that are excluded. If you look at the summary, and I can just name a few, but that are excluded from these different changes to what can be required or what is allowed within the scope of a security deposit and personal guarantee, but it does not include residential property, lodging, office space, research and development laboratories, medical practices, clinics and dispensaries, and farming or cultivation. So when I first saw this and first had it come through and was seeing what the city of Seattle was doing here, we can take a step back and look at why they're doing this. I think it's from my understanding of everything and hearing about how this came to be was the promotion right now that they're trying to get through in the city of Seattle is with helping retail and restaurants. That's a primary driver of where they are seeing a lot of businesses that ended up failing within COVID and didn't have the same protections, and you had an outstanding, security deposit or personal guarantee, and they were just seeing a lot of issues coming with it. And so what that was doing on the market side was there's greater basically hurdles to get into the market, start a new business. If you're going with a restaurant or retail, you can see a situation where somebody would be hesitant to come into the Seattle area, start a restaurant when it's saying, hey, you're going to personally guarantee the entirety of this lease throughout the side of it, or you're going to have this much in a security deposit relating to the lease, and that might be a substantial hurdle for somebody to start a business. So the promotion here is obviously trying to foster more new growth, more businesses, but it's really looks like it's focused on the retail and restaurant side of things. And the big reason that I wanted to put this alert out there for anybody that's in this area or has the commercial properties is tomorrow is the city of Seattle kind of deadline date for notifying your current and existing tenants or new tenants that are entering into a lease of these changes. Now, there is a copy of the summary of the commercial lease requirements, and that's part of the link in the chat. So you can look through that, but that is what has been developed from the city of Seattle. And that is the summary that owners and landlords are required to send to their tenants. There comes with this some pretty, when you look at it and actually read, there's some pretty substantial penalties for not fulfilling the obligation for notification and sending this out to current and coming up existing and then also tenants that are coming into a space and giving them notice of these new changes. And so I just wanted to make everybody aware of that, kind of put it on the alert spectrum. You have friends, clients, colleagues that are in this commercial side that haven't heard of this and are dealing with tenants in the city of Seattle. It's just something to keep in mind. I am suggesting, just as a catch-all, there's no harm in sending this to all tenants, right? The law as it's written has certain exemptions that we went through of who applies for this. But if you're dealing with on a high level and it's of no value, it doesn't matter in the grand scheme of things. I just think it's better safe to get these out and just have a catch-all on everything rather than thinking, oh, this tenant doesn't qualify for the notification, therefore I don't have to send it. So that is just my high level thoughts on that and where that's going. But again, it looks like just a active way to that the Seattle is trying to promote some new business growth within its city limits. And that's just a quick primer on that front. And now we did want to jump into what we're seeing kind of on the residential side of specifically I should say the county that we've encountered the most problems and flux with this issue is King County. In other counties, it's still a substantial issue. And Jobel, if you can go to the next slide here. It's still a substantial issue, but it's from what we've seen, it's nowhere near kind of the backlog that we're seeing in the King County side of things and the case backups there. And so I'll let Phil jump in here kind of on what we're seeing here.
So a little bit of background on unlawful detainer proceedings. First off, before you even start a lawsuit, you have to give a pre-eviction notice. Then you'd serve a summons and complaint. If the tenant responds, then you have to set a hearing called a show cause hearing. So under statute, show cause hearings are supposed to be set between 7 to 30 days between filing the show cause pleadings. However, that requirement is completely ignored in King County. As of right now, we're seeing a lot of backup with show cause hearings. And the initial hearing is generally not scheduled until mid-early of next year if we were to file pleadings today. To expand upon that even more, the first hearing is not a hearing in which, unless the tenant fails to appear, that the case would be heard and a judgment would be rendered. So usually at the first hearing, if the tenant will appear without counsel, the court will allow the tenant to be screened by the Housing Justice Project. And if they qualify, then counsel will be appointed for the tenants. This stems from a statutory change that was enacted after COVID, which entitled resident and indigent residential tenants to free counsel and eviction proceedings. So after first hearing is continued, you'll have a second hearing if a settlement can't be reached. And at the second hearing, you might be able to get a final decision on the merits from the court. However, even then, we're seeing a large uptick in motions for revision. Motions for revision are similar to appeals. They are basically they're the losing party asking the judge to reverse a commissioner's decision. So with the uptick in motions for revision, unfortunately, this means that the process has become a lot longer than it's intended to be by statute. And it does unfortunately increase costs on the landlord side. I recently had a motion for revision that thankfully I was able to prevail on, but it's again, the time and cost can be quite frustrating on the landlord's end. So the reality of this is that one, the court is attempting to address the backlog. They're looking into, for example, getting more commissioners, setting aside more time on the calendar to be able to hear more show cause hearings. So we are staying tuned for that, and we may look into resetting certain hearings if earlier dates eventually become available. But this will realistically be addressed through both administrative changes and through legislative changes. So if you'd like to voice your frustrations, we recommend that you contact your local representative. On top of that, there are a lot of landlord groups such as RAWA, the Rental Housing Association of Washington, These groups, especially RAWA, are pretty good about providing updates on developments in local counties with respect to eviction proceedings. So definitely something to look into if you're a landlord.
And what's really interesting here with the backlogs is, and we'll get into this a little bit later, but it's kind of a primer on where all these proceedings used to be. And if you guys had experience with it pre-COVID, these were relatively quick and efficient proceedings. The primary aspect of the court in these hearings was to determine who had a possessory right. And so a lot of times it was a basic question from the commissioners, as a lot of the eviction side of things and unlawful detainers would be based on non-payment of rent. So it became this a fairly clear, hey, was rent paid? No. Okay, then do you have any other defense for why rent isn't paid? And looking at it from that side point, I mean, I can sit here today in front of you guys and say, obviously that makes sense from a reasonableness standard. This is a property that's being rented. There's a specific contract that they are paying to have access and possession of the property. And so without the payment of rent, where does that really leave it? It's a clear breach of the contract. The unfortunate aspect of where we're at now is that decision on, hey, is it just, are we just looking at the contract side? There's so many other things that have come into it. So this has become a very, very extremely technical aspect of litigation. And really it comes down to commissioners are looking through everything with a fine-tooth comb. It's strictly construed against the property owners in this area. So a lot of times there's issues with the original notice that might have gone out. There's issues with how things are broken down in a notice. There's issues with proof on certain aspects of it. And Jobel, if you can go to the next slide here, we'll run through some of these items. And so getting back to the historical features of it, there was a more, I think of it as a reasonable approach. I can see how people have a different varying views on the issue, and I'm not here to debate the policy side of it, but from a legal side of it, when you want to analyze something, you're looking, okay, is there a breach? Is there a breach? How is this cured? What is the remedy out there? And the unfortunate part about where everything is right now within this setting is you're looking at starting an action with the pre-notice. Then if nothing happens with the tenant, if they don't move out, if there's not an agreement after that notice goes out, you're looking at a summons and complaint, and then having that served. And then once that's served, looking and setting up when the first show cause hearing can be set. And that is what we were talking about, what Phil was speaking to, was that backlog has caused the calendaring of that initial hearing out into next year, which when you think about it, if you're in that setting as an owner and you have an individual in the property that's not paying rent, it's obviously a very frustrating situation, because the reality is once that process is started, you're likely not getting any more communications. You're not getting payments on things. Things are very difficult to resolve. So it is kind of this last effort on this after exhausting all amicable resolutions with a tenant. And unfortunately, there is a reality that sometimes allowing people to walk away from an outstanding amount is within the best interest of everybody. And that's a practical reality with situations where if there's outstanding rent and people are having a difficulty paying, the prospect of them going further into rent debt and having some sort of recovery from an owner side, it just gets further and further down the line. So there is this component of it where it's exhausting everything you can, but there is a time and place for it. And one of the things that comes up pretty frequently on our end is the non-monetary defaults. And when we're talking about non-monetary, we're talking about issues with the property, how it's being cared for. Maybe there's substantial junk that's piling up in the front yard. Maybe there's a breach of some condition of the lease, inviting somebody there to stay there that wasn't on the lease, having a pet in the apartment, or a unit that wasn't on the lease, and there's a no pet policy. There's also, and that's when I talk about those, I'm talking about breaches of the lease that are non-monetary, and a tenant is allowed a 10-day right to cure. And then when we talk about a 3-day, which you see in this slide, the basis on 3 days is a higher level, and a 3-day is a basis for a 3-day notice of termination. And when we look at that, generally we're talking about an illegal action has occurred at the property. There's been substantial waste caused by the tenant, that's very provable, and that can be issued. And there's no cure period on a 3-day. There is a cure period on the 10-day when you're asking, okay, are they going to continue to have this pet there? Are they able to relocate it or whatever it is? And that cures the breach. Now, these are extremely difficult right now in the setting with the unlawful detainers. On the 3-day notice of illegal activity, there's the requirement, at least within King County, is almost unequivocally all the commissioners are asking for the police report that's associated with it, and looking for an actual arrest that's committed by the tenant at the property. Okay, so you're looking at situations where it becomes very difficult. And again, this is one of these kind of frustration points, because you're now coordinating with the applicable police department, whether it's the King County Sheriff with the Seattle Police, and trying to get a report back from them. Those reports don't appear overnight. They sometimes take time. You've got to request a report, so you're waiting on that. And a lot of these are, you're talking about pretty severe critical issues going on. There can be threats to other tenants. We've seen gun violence and threats to other tenants where there wasn't an arrest, but very clear from video evidence, from everything else. But that was still, it still becomes a very a big hesitation from the courts to look at that as a termination event, which is frustrating. As property owners, as attorneys in personal life, you don't want to see somebody in a situation where there's a tense and actually violent threats being made, but feel powerless to it. And so these are one of those things that they've been trying to address more steadily on the non-monetary defaults, but they still are just extremely difficult to get an actual ruling in an owner's favor on these without a substantial amount of evidence is very hard to get together. So if you see this and options are going on, and we can sympathize, we're very empathetic towards clients that have these situations, and obviously it's a very bad situation with a tenant, frustrating for the other tenants at the property. And so there is this distinct reality that something has to be done. It's just, it just comes with, is that going to be enough for the court? And that's the gray area. We don't know. We put everything we can together, the police reports, declarations from other tenants, video evidence. We use all that to create the story, so that the judge seeing this will say, or a commissioner seeing it, looks at it and says, this is a major issue. We need to protect not only the property, but we need to protect the other tenants, and this person needs to be removed from the environment, from the situation. So if Phil, do you have any other kind of comments on the non-monetary defaults there?
So I can't quite recall if we touched upon this, but the court is they have implemented an emergency calendar for activity, I believe, that impacts the safety of other tenants. So there is a comparatively, and I use the word comparatively here, speedier process for getting a hearing than on these type of notices in King County than for example, non-payment of rent. That being said, as Rob has emphasized, one, usually at the first hearing, you'll get a continuance because the tenant has to be appointed counsel, and two, since these are evictions that are very fact/evidentiary based, you'll see a lot of these evictions get set for trial, which again it will extend the case further. It can be difficult to prevail if you don't have a police report or you have insufficient evidence to prove that the violations are ongoing. But there's some sign of positive progress in the sense that they have developed this emergency calendar.
And to elaborate on one other point there, because there's this kind of, there is a feeling out there from time to time, and I completely understand it, that, okay, well, if we're not able to move forward and actually be successful on one of these, why would we even try if we have one of these, why should I be spending the money to try to do this? And the general aspect that I have and the general take I have on this is, if it's a situation dealing with other tenants, then there's this added responsibility from the property owner or the property manager side of things to at least make efforts to try to resolve that if it's a safety component. And where I have a kind of a sleeplessness on it is because, yes, you feel like your hands are tied, but if you don't do anything, and let's say something were to happen, then is another tenant pointing at the owner or the property manager and saying, well, they didn't take any action after this person did X, Y, Z. And so at the very base level, there can be this acknowledgement that, hey, we went through and started the process. Whether or not the court agrees with us is irrelevant to the fact that we did everything reasonable within our power as the owner or the property manager in that given situation. So it's just something to consider when you are faced with those very difficult. No, these are not fun situations, because it's usually a very traumatic issue with other tenants. It's I've seen a lot of abuse of property management issues. I've seen theft from the property manager's office. I've seen broken windows, cars vandalized. You know, there's other tenants' house broken into, packages stolen and recovered from you know, a next door neighbor. And so it's just these really odd and tense issues. But sitting back and doing nothing in those situations is not something recommended. It may feel a little bit helpless, but you still have to acknowledge that there is an issue and try to figure out what ways to resolve it. And sometimes that communication, or sometimes getting that notice out, is enough to at least promote a conversation with the offending tenant, or look at it from the prospect of the other tenant saying, hey, we're doing what we can. There's a backup with the court. There's all these issues that go into it, but we're looking at these issues.
And to piggyback what Rob is saying too, another reason I think that litigation in these type of situations, or at least serving a notice, is still worth pursuing, is because settlement is always a possibility. We'll talk a little bit more on recent developments with respect to settlement agreements and unlawful detainer actions. But even in unlawful activity evictions, settlements do happen, and they can result in the tenant actually moving out. Another note as well: always contact the police if you believe there's any unlawful activity going on at the property, because if it does result in the arrest, it could lead to a police report and ultimately the basis for an eviction based on unlawful activity.
And to that point as well, even if it doesn't lead to a, you know, quote unquote arrest in that situation, there's at least now a third party record of an offense at the property, rather than just relying on somebody's declaration that may be the owner, the property manager. You know, you now have an official report at least that tracks what was being said or what was taken from the Seattle police. And again, the timing on those is a little bit of the frustration, because it does take a while to get those reports back. But that shouldn't stop you from, at least if there is a concern for a tenant, if there's a concern at the property, that there should be a call in, especially if it's a safety issue, to the police to at least get that on record and have the safety component covered. Joelle, if you can go to the next slide. Okay, and this is another point, and I just wanted to reiterate, and we spoke on this at the very beginning, but this whole process is predicated on notices. The notices to actually move forward with an unlawful detainer are a precondition to the suit. So proper notice has to be done prior to an actual filing for, if it comes down to it, for the removal of a tenant. And so we do see a lot of these that will come in, and somebody has tried to put together the notice. You know, they've found a form, they've gone out, they've maybe served the form or whatever it may be, and we do have to look at that notice at that point and really come down to sometimes it's a hard conversation because you've issued a 30-day notice. Okay, let's just take a perfect example. 30-day notice, which is required for non-payment, notice to pay or vacates with any property that's got a federally backed mortgage. And so let's say you've read that, you understand it's 30 days. You go out there, you issue the notice. On day 31, you go check on the property. There's been no payment. No one has moved. You say, okay, well, now I can move forward with the unlawful detainer process. I'm going to contact, Rob or Phil on this, and we'll get that notice. And there's times where we have to give the unfortunate news, which is I wouldn't move forward with this notice because it's not going to hold up once we file the unlawful detainer. And a lot of the issues that we've seen from the commissioner's side is it's so strictly construed that there's all these technical defenses, there's all these technical realities of what can and cannot be in the notice. Specifically, there's been a lot of issues where there's a total amount and the ledger says a total amount. And everybody knows what that amount relates to. And it's put in the notice just as a total amount, but it's not broken down as to which months it relates to and whether it's utilities versus rent. And so we've seen a pretty consistent ruling from all the commissioners across the board that is not a valid notice because it doesn't reasonably break down the months and the types of charges that are done on that. So if you are putting one of these together and you're looking at it from that perspective that you're in an unfortunate event where you've got to serve the notice on your tenant, you just need to be very clear in breaking down all those charges, what they relate to and the months they relate to, so that it's just unequivocally clear and broken down. The old guard process of putting the lump sum together, where everybody knows that is, I mean, it matches with the ledger, there's no dispute on that. And I think that's where the frustration comes. There's no dispute on the amounts that are usually owed. It's how that notice was actually presented. And that obviously is a big frustration for people that are going through the process. When they go down this, they get a show cause hearing 6 months down the road, the court looks at it and says, well, no, I don't have jurisdiction because I don't think the notice was specific enough to proceed on. And so the case unfortunately gets dismissed and you're starting the whole process over. And during that whole time, you're not receiving rent, you're not receiving any kind of communications with the tenants. So those are very frustrating aspects of it. And so we always want to be very critical on that initial stage. And to give another plug for some of the rental associations around Washington, this is a great resource, right? Using these RAWA, they have a form database, if you're a member, and they keep that updated, and they have applicable notices to pay or vacate for, applicable to Seattle. It contains the specific required Seattle language. They have them for different municipalities and for King County, for different cities within the state. And so when you look at that and you're thinking about, oh, is this going to be a good thing for me to join? I do see a lot of value in those, and it does help put those things in perspective and help you. Going online, there's so much information that you can get online, which is good, and it's bad because you can get something that's not up to snuff, it's not the right form, and you go to proceed on it, and all of a sudden it's kicked out just because it didn't have some specific language. It's a huge technical defeat, but it's still, nonetheless, it prevents moving forward with the action. The other thing to keep in mind on these, and we addressed kind of the non-monetary defects, when you are putting those notices together, you've got to be very, very clear on the details of what the cause is. If it's a 3-day notice, especially if there's arrest, what specifically happened. They threatened another tenant with a gun. They posted that they were going to harm their family on their door and left it there. You need to have that very clearly put out, dates and who witnessed it helps a bunch, because you can get those declarations together to support it. If there's other tenants that are willing to testify, and that becomes another difficult aspect of this, because if you're dealing with somebody that's already threatened somebody or threatened tenants, and other tenants have witnessed it, it is unfortunately a very difficult thing to get people to come forward to provide a declaration for what's going on. There's a distinct fear for their own safety, and it's understandable, but it's just a reality that we're faced with in those situations. The other thing to be cognizant of is, under the statute, the notices are only effective for 60 days after it's been served. So you have to take action within those 60 days on any particular notice. Otherwise, that notice is basically invalid. It's defective at that point. If you try to move forward after that 60-day time frame, you can run into some substantial defenses and dismissal of the overall claim. Now, where that comes into it comes kind of difficult is when you're talking about a 30-day notice, right? If you're already going through and served it and 30 days have gone by, and you're looking at 30 additional more days, you've got to make the decision on whether or not you want to move forward with something within that time frame. So if you have a tenant that's consistently behind on rent, consistently late, I always say, get in the habit of doing it monthly. Don't wait, for 2 months, 3 months, or whatever it is, to accumulate and issue a notice and then wait, see what happens. I would be issuing them, being proactive on it, just for the sake, if they don't cure the default that's issued, then you at least can have an option of moving forward. And 2, if you're accumulating this record of the consistency of the defaults and the consistency of the issues going on with the lease, you're in a better position with the court from that standpoint, and you have more options if you're not waiting too long on that. Phil, do you have anything to add on that the service timeline?
Yeah, I actually would like to touch a little bit on service itself. Before I go into that, I should note on the 60-day timeline, we were recently able to get a favorable ruling when attempts at service of the complaint were made, but service was not perfected, meaning we did not necessarily complete the service process. However, this was just in Superior Court. It did not go up on appeal. So hard to say how all judges would rule on the issue. It's possible it's possible they may require perfection of service. We just aren't entirely sure at this point. Now, with respect to service of the notice, there are also particular procedural requirements you have to follow. When serving the notice, you have to print out copies for each named tenant and an extra one for all other occupants. You have to knock on the door. If the tenant answers, you hand all copies of the notice to the tenant. If they don't, you tape all copies face up to the door and you mail copies to the premises. There are also local requirements that you may need to be aware of. For example, on 3-day notices for unlawful activity in Seattle, you need to send a copy of the notice to the Seattle Department of Construction and Inspections. If you fail to do so, the tenant might raise it as a defense in an eviction action based on that notice. Also, with Section 8 tenants, you need to provide copies of the notice and of the complaint as well to the housing authority when serving.
And so these are all, it all becomes very, very technical. It's one of these things. I'm never you know, you're never actually going to do it within the court settings, but I'm always curious about how much the commissioners and the judges actually understand about the background process rather than just pointing out singular, singular technical issues with it. Because it is all encompassing. If you aren't in this and know it on the consistently updated basis, there are so many pitfalls for this. And so it just becomes very frustrating because you think, oh, this is how it was done even a month ago. And all of a sudden you run into a new issue. And it may be a creation of how a commissioner has been ruling on things recently. So it's not even a quote unquote law. It's not codified, but we see these things, and we've got a good, there's a good group of colleagues that we all exchange ideas, thoughts on everything here. So you see different commissioners, how they're ruling on different aspects of it, and can understand and play into that a little bit and just know the reality of where a case may or may not go in front of any particular commissioner. And so one of the things that has come up recently as well, that's kind of put a little more things into flux. And Jobel, if you can go to the next slide here. If people are paying attention at all, this is a big update, and the ability to use settlement agreements to basically resolve landlord-tenant issues, which I think everybody would agree that if people are in agreement on something, moving forward on that aspect is beneficial for everyone, and if they're all signing off on it. But unfortunately, there's been some case law and appeal that has thrown that into the mix. And so I'll let Phil run with this.
Yeah, so a little bit of background on the Princeton case. It involved a landlord suing the tenant for unlawful detainer. The landlord and the tenant, both of whom were represented by counsel, entered into a settlement agreement. One of the terms of the settlement agreement was that the tenant had to make payments pursuant to the agreement, and if they failed to do so, the landlord could move for a writ ex parte without notice to the tenant. That is, they could ask the court for a writ without having a hearing and without letting the tenant know. So sure enough, the tenant did not make a payment under the agreement. Landlord attempted to move for a writ. The Court of Appeals held that the settlement agreement was invalid because it waived a right of the tenant, meaning that a tenant didn't have a right to a hearing over the issue. The agreement provided that the landlord could move for the writ without even notifying the tenant. So unfortunately, even though frustratingly, the agreement was reviewed not only by both parties, but by their attorneys too, and everyone was in agreement on the terms, the court said that the landlord could not get a writ in this instance. So some takeaways from this is that, one, obviously settlement agreements that waive statutory tenant rights they may be deemed invalid. This has led to a lot of restructuring of settlement agreements as of lately. You need to be very, very careful not to waive any tenant rights provided by statute in any agreements with the other party. A lot of times what we're seeing is parties enter agreed findings of fact and an agreed judgment or order with the court, instead of having a separate settlement agreement that might not even be filed with the court. So is settlement impossible? Not necessarily, but it requires a lot more care and attention than it used to, and it could be more difficult to enforce settlement agreements these days.
And to jump on that, so the big part that used to be a pretty standard practice point, if a tenant and landlord were able to get into an agreement, and it was just based on, hey, timing of everything. Yeah, we agree to move out. We'll be out of the unit by X date. Okay. And maybe even there's a waiver of the back rent. There's all these things going into it. So that was a pretty standard thing. And within those, a lot of the times the parties would agree that a writ would be issued, but just not executed upon, or as this case pointed out, that the writ could be obtained ex parte, meaning everybody agrees that, you know, in a particular situation, for the example that I was using, if you're not out of the property by X date, that, and it's confirmed, that I can go to the court and get the writ issued, and then I can look to have the sheriff's office proceed with removal upon the writ. And so it seems reasonable in those stands when everybody's agreeing to it, and it's just following through with an agreement. It's unfortunately a lot of that stuff is being second guessed, which is unfortunately leading to increased costs for not only the landlords and owners, but also for tenants. This is one of the things that's kind of, there's been a lot of pushback actually from both sides of this, of eviscerating this ability to really freely get something done that's actually within the interest of maybe the tenant and the landlord at the same time, and parties just want to have it done. And unfortunately, people are revisiting that, because now the reality is, if that's being looked at from this different lens within the court, will that be effective? Is there a point of me even entering into a settlement agreement if it comes out that, you know, some portion of it doesn't get fulfilled? Then I can't even move forward on it. So what's the point of spending the time, energy, and money on it? And that's where we've had this, there's been a lot of discussions from both sides about the reality of kind of what the court has seen on this. And I believe, I don't have the update on when this is supposed to be heard, but I do believe this is going to be an issue that's going to appear at some point within the Supreme Court of Washington, because it is a big issue, and there's been a lot of backlash actually from both sides of the table on how the court ruled and came to their conclusions and legal reasoning on this one. Okay, and then Jobel, if you can go to the next slide.
Also, just thought I'd add, we do have an article on our website regarding the Princeton decision that Rob and I both worked on. So if you have time, it is worth a read if you want more information on that.
Right, and that's that can also be found in the chat as well. So there's a link to that. And so this is one of the last topics that we wanted to touch on today, and just looking at the time frames on everything. But there is in Washington, the unlawful detainer statute was supposed to be a quicker resolution towards possession of property, and obviously we've seen that kind of turned upside down, and just purely on the case scheduling side of things. So the other route that a lot of people are looking more realistically at is called ejectment. And this is a similar path where previously it had been a substantially longer road than the unlawful detainer. It's now looking as a more and more reasonable path. There's some nuances to it that we'll discuss, but in an ejectment action, the differences between ejectment versus a unlawful detainer is this is a stereotypical, I say stereotypical, but it's a case that's filed within the Superior Court of the county that runs along the same and similar trial schedule as any normal civil litigation. So what you're asking for usually in an ejectment action when you're dealing with somebody in a property is similar to the unlawful detainer, possession of the property and payments of back rents on amounts that were owed. So it's a similar process, different name, but it does not get that expedited case schedule that you used to see with unlawful detainers. So what we're seeing a lot of people turning to, and this is also in particular for issues that are dealing with maybe unauthorized individuals within the property, illegal activity, those kind of things. People are turning to ejectment and looking at that as a course of action, and trying to either look for a temporary restraining order or using that route in combination with an early motion for summary judgment. And what that means in the context of the legal is you are asking the court to make a ruling because there's no questions of fact related to something. So the court can make a determination based on law to give you what you're requesting in the case at an earlier point than the trial. Now, the risk of an ejectment is if you are not successful on those early hearings, and if the tenant is raising defenses, counterclaims, this can create a situation where you're stuck in litigation on a trial schedule. And so it's case specific, and case selection is highly critical on when and where to use the ejectment action, but it can be very beneficial, and it avoids a lot of the common pitfalls that get a unlawful detainer removed on a technicality. Because moving forward on the ejectment side of things, it's not strictly construed against the owners anymore. It's a traditional case, and really you're looking at within the legal side of things, the breach of contract under the lease, along with who has the underlying possessory rights to the property. Phil, if you have anything to add on that front, with regards to ejectment versus the unlawful detainer, feel free to jump in.
Not too much, to be honest. A lot of times, in order to get to the point of a motion for summary judgment, you'll need to go through discovery. So that will be an added cost on the landlord side, and you are going to have to wait for discovery responses. And it could even be the case that there's enough in dispute that maybe a motion for summary judgment isn't worth filing. But that being said, I would say that it is starting to look like a more attractive route in King County, where we are currently seeing a lot of delays in unlawful detainer proceedings. I've heard from some of my colleagues that some of the judges are a little less swayed by some of the hyper-technical arguments that the commissioners might dismiss an unlawful detainer action on. Though I would imagine that depends heavily on which judge you're appearing in front of.
The other added bonus, if you can think of it that way, anytime you're entering into the courts, I don't think it's ever a bonus, but the other added benefit to ejectment is that, let's say the possession claim maybe has technical issues or something of that nature. You still have your breach of contract claim that can be pursued on a money judgment side of things. And so there's leverage there, right? There's an ability to continue down that path, and if nothing else, get a monetary judgment out there. So there's pluses and minuses to both routes. But as Phil was elaborating there, it's becoming a more and more viable option in a lot of situations to look at ejectment over the unlawful detainer. And I think there's a quick question here, and it's a great question because we've been running through this. And it's concerning the ejectment actions, and is the tenant supplied with a court-appointed attorney if they can't afford one? So this is an interesting gray area within the law right now. We've seen a little from both sides of it. There's been arguments that the appointment of an attorney with regards to the programs that have been created is reserved for the unlawful detainer side of things, and people have made that argument. But we have seen appearances, and those appearances come on a quote-unquote pro bono rather than a court-appointed attorney on the civil side. So for ejectment, so it's not. Unfortunately, I can't say, yeah, there's no ability for them to get the appointment of counsel. It's just not the same sort of process that's straightforward on the unlawful detainer side of things. And I think there's going to be some revisiting of these whole programs. Candidly, we on the outside don't see what is really being used as a screening criteria for individuals to meet under this. And I think there's been a lot more scrutiny on what's actually being done to screen and see people. There's been some cases that have come out where people were appointed counsel, and it turns out they have a substantial income per year that wouldn't have qualified for them in those scenarios. So I think they're looking at it a little more closely. I think originally it was kind of a foregone conclusion. I don't think anybody was really measuring that up and saying, okay, well, is somebody going to get appointed? Do they qualify? I think everything we would just go into it with the assumption that there's going to be a court-appointed attorney that's going to be appearing, and that's predominantly for, you know, still 99% of the cases that end up going that route. But there's no definitive answer on whether or not you will see some sort of free or pro bono attorney on an ejectment side. Great question though, because that's something we're waiting to see as well. Well, if there's any other questions, we are happy to stay for a little while here. We've got one, and this is more just like a quick little reminder and this is only because this question comes up so much in Seattle, and people will contact us and be like, and sit down and say, hey, this lease is expiring in 15 days. So if they don't leave, I can just get them out of the house, right? And for Washington and in Seattle, you just got to be aware of county to county what the requirements are for offering renewals of lease. And you have to be sure to calendar that out when you're entering a lease, just so you know you're on the same page and are meeting the notice requirements for either non-renewal or renewing and extending, because otherwise you do fall into the de facto month-to-month category. And that can be some people are okay with it. Some people, it becomes a very difficult thing once you're on the month-to-month if a tenant, if something, God forbid, something bad happens with the tenant, to actually get that tenant out of this place. So I just wanted to kind of ingrain in everybody's head really quick, if nothing else on this last slide, is the renewal aspects of it, and understand what is required in your particular jurisdiction with regards to notice of non-renewal or renewal, because it does convert it to a month-to-month.
I would also add too that if the renewal requirements are not complied with under Seattle law, the tenant may have a cause of action for 3 times the rent plus attorney's fees and costs. So it would probably be a small claims action against the landlord.
Right, and that's a good point, and that's the other aspect of this with all the laws. There's been a lot of we've seen an uptick in private actions where tenants are coming back, whether it's on deposit disputes, whether it's on violations of a notice or anything like that. And those they're so technical and they cause a lot of headaches. So it's just really good to stay updated on everything that's going on within your jurisdiction if you have a rental. And like I said, if you reach out to Phil or I, we are more than happy to discuss any of these items. Our contact information is in the slides, and if we haven't met a lot of you, please feel free to reach out via email. I'm happy to spend some time, discuss anything. Phil is as well. And that's it for the webinar. Just reach out via our contact information. We really appreciate everybody taking the time today. Thank you.
Thank you.